How to satisfy a tough EB-1 requirement.
Greetings. I am attorney Edwin Fogam. Our topic for today is how to crack the toughest prong of the EB-2 National Interest Waiver Petition. EB-2 National Interest Waiver petitions are employment-based national interest waiver petitions that can be filed by foreign nationals who can demonstrate that their endeavor is beneficial to the national interests of the United States. If they do this, they don't need a job offer or an employer to petition for them. However, this particular petition is governed by Matter of Dhanasar, a case that came up that established 3 requirements for the foreign national to be granted a green card based on this petition. The first is that the foreign national must demonstrate that their work has substantial merit and national importance. Secondly, they must show that they are well positioned to advance this work or this endeavor in the United States. And third, they need to show that on the balance, it will be beneficial to the national interests of the United States to waive the labor certification process. Now, generally, the first 2 requirements can be met quite easily, but the third is very challenging. Why? Because the labor certification process, generally known as PERM, is meant to test the market and to try to secure or get American workers to work in that position. So to waive that, the foreign national has to demonstrate that what they are going to do is really, on the balance, more beneficial to the United States than the United States' interest in having the market tested and having Americans work. So that is the bar. I want to give you four strategies to use. The first strategy is time. The foreign nationals petition should demonstrate that time is of the essence, that if they were to go through the labor certification process, which is very lengthy, then it will affect the national interests of the United States, especially if they are involved in some serious research or some time-sensitive type of work. Secondly, urgency. The foreign national can demonstrate that their work is urgent, which ties in with time, but the urgency of their own research or what they are actually trying to finish or what they intend to continue doing. And thirdly, the foreign national can focus also on the fact that there is scarcity of workers in that field. In this case, demonstrating that it is not necessary to test the market through the labor certification process. And you can do this by objective evidence, showing the shortage in those sensitive professions or endeavors. And finally, the foreign national can use their personal immigration circumstances. For example, if they are in OPT, optional practical training, and will not have the time to go through labor certification when it expires, or H-1B, or they are in some sort of an F1 postdoctoral program, this can be emphasized that because of this, it will be beneficial for them to go through the national interest waiver route instead of going through the lengthy labor certification process. So I hope this information was helpful to you. If you have any further questions, please feel free to call us 301-608-1555. You can also send us an email to ekfogam@fogamlaw.com. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.